This podcast is a production of Widener Law Commonwealth in Harrisburg, Pennsylvania. For more information, visit commonwealthlaw.widener.edu/podcast. Keeping up with the latest legal thinking can be challenging. Our educational programs help you stay tuned into the legal profession. The following is a recording from the 2020 Environmental Law and Sustainability Center Distinguished Speaker Series entitled Earth and Trust: Inalienable Rights for a Collective Ecological Future.
Well, good day, everybody. I thank you all for being here. My name is John Dernbach, and I direct the Environmental Law and Sustainability Center at Widener University Commonwealth Law School. Welcome to the Distinguished Environmental Speaker Series. This is the 11th year of our speaker series. We've made a point of inviting highly qualified speakers from a variety of backgrounds and perspectives. We've also made a point of giving our speakers the opportunity to reach beyond the academy and into the broader community. Today's speaker is Professor Mary Christina Wood, and I'm honored to have her join us. She is a Philip H.Knight Professor of Law at the University of Oregon and Faculty Director of the law school's nationally acclaimed Environmental Law and Natural Resources Law program. Her research focuses on a fundamental rights approach to ecological restoration and distribution of resources. She is one of the foremost authorities in the world on the public trust principle and is widely credited with originating the approach used in youth-led litigation across the U.S. and in other countries around the world, invoking the principle to hold government accountable for promoting the fossil fuel energy system. The most prominent of these cases, familiar to many of you, is Juliana versus United States. She is a frequent speaker on global warming issues and has received national and international attention for her sovereign trust approach to global climate policy. Professor Wood is author of Nature's Trust: Environmental Law for a New Ecological Age that was published several years ago by Cambridge University Press. She is also the author of textbooks, book chapters, monographs, and articles spanning environmental and natural resources law, tribal sovereignty, and the climate crisis. Her presentation today, Earth and Trust: Inalienable Rights for a Collective Ecological Future, is an important talk about an important topic. The concept of a public trust in natural resources has grown steadily in importance in recent decades. Pennsylvanians are probably most familiar with the public trust because of landmark Pennsylvania Supreme Court cases in 2013 and 2017 that brought new life to Pennsylvania's constitutional public trust, embodied in Article 1, Section 27 of the state constitution. The basic idea in Pennsylvania, other states, and in other countries is that governments are trustees for much of the natural world. As trustees, they have a fundamental duty to protect the natural world with prudence and loyalty. You might think about it as having the same fiduciary duties that a banker or other trustee must provide for your savings or checking account or for your retirement account. She will be speaking today about the broader implications of the public trust. One administrative announcement before we begin. For those of you who want CLE credit for this program, please see the link to the evaluation form that will be put in the chat feature toward the end of the program. You must fill out the evaluation to get credit. And now I'm going to step away and ask you all to please welcome Professor Mary Wood.
Well, thank you so much. I assume everybody can hear me just fine. And I want to thank the law school so much for inviting me to do this distinguished lecture and for the audience for joining. And for that very kind introduction by Professor John Dernbach. We stand at a very crucial moment in time right now, where hurricanes are demolishing towns and wildfire infernos are burning them to the ground, and tipping points are looming just ahead, and we're amidst a sixth major extinction on the planet now underway. And meanwhile, communities of color and less wealth are grappling with soaring cancer rates and a legacy of poisons from toxic waste sites that were deliberately placed at their doorstep. And all of this happened with permission from a system of statutory law that has been in place for over half a century now. The failure of statutory law leaves us at a crossroads, particularly in the wake of an election where now we must decide whether to piece back a broken regulatory system, ignoring the dysfunction that has delivered so much ecological collapse and injustice, or whether we now reach deeper into the law to anchor those legal obligations into fundamental legal rights, ecological rights that are inherent to humankind. And so, hoping to illuminate this crossroads, my talk today is entitled Earth in Trust, and I'm going to share PowerPoint with you, and we'll move through it as we go. So I'll talk about inalienable rights for a collective ecological future. And I have to say first that the Widener University academic community is a powerhouse of fundamental rights jurisprudence or scholarship rather, with Professor John Dernbach being the leading authority on express constitutionalization of the public trust principle, and then Professors Aaron Daly and James May being leading authorities of fundamental rights jurisprudence globally. So I should say at the outset, I hope you can all appreciate how very humbled I am to be in the company of these major scholars in the field, and how honored I am to be with you all today. And as Professor Dernbach said, the Pennsylvania Supreme Court is itself at the epicenter of emerging fundamental rights jurisprudence. Before we proceed, I would like to dedicate my remarks today to a man who has created a historic legacy, as you will see, Senator Franklin Curry. And he is the drafter of the celebrated Environmental Rights Amendment that I'll be talking about in the Pennsylvania Constitution, and a global pioneer in conceptualizing constitutional environmental rights and then getting them enacted. And I believe that Senator and Mrs. Curry are with us today in the audience. So I want to begin with our climate reality and then move into how we got here with statutory law, and then dive into the public trust principle and end with the court's role in climate crisis. That's our agenda. And I want to start with a premise that everybody seems to take for granted, that as Justice Holmes said, the law is the felt necessities of the times. It should be relevant to the harm we are perceiving right now. And I think we have to appreciate this moment that we're in and try to match the law with the reality of the threatening situation we are facing right now. What is that situation? Well, we know one thing: environmental statutes have been on the books for 50 years. These are the Clean Air Act, the Clean Water Act, the Endangered Species Act, and such. And they were designed to protect the environment. But our situation now is very well expressed by this quote from science writer Elizabeth Colbert, who says, "It may seem impossible to believe that a technologically advanced society could choose in essence to destroy itself, but that is what we are now in the process of doing." For all this period of time during the statutory law, we've encouraged through federal policy and state policy a fossil fuel energy system that has had not only devastating landscape effects and effects on species and waters, but also the burning of those fossil fuels has caused emissions that has destroyed the balance of our climate. And so let's talk just momentarily about our climate reality, because if we don't understand that, there's no possibility of our trying to bring the law into alignment with the reality of our situation. And so just very simply, leading scientists say that we have to return to an atmospheric concentration of carbon dioxide of 350 parts per million. That's the highest possible safe level. And we are now soaring beyond that at 410 and growing parts per million. Now, I'm going to talk about the Juliana versus United States case later, but just to give you a sense of what is agreed upon, this is what a panel of Ninth Circuit judges just found and declared in January of this year, that our carbon dioxide emissions have skyrocketed to levels not seen for 3 million years, and that this is wreaking havoc on the Earth's climate system. It shows no signs of abating because the federal government is promoting a fossil fuel policy. Now, where would this lead? By the end of the century, it would lead to approximately 11 degrees Fahrenheit increase of temperatures over pre-industrial levels. And that, quite simply, is not broadly survivable by humans. Now we have, because we've let this problem go for decades, this scenario of urgency that the law has never really dealt with. And it has to do, and is caused from dangerous feedback loops that nature itself creates. Dangerous feedback loops mean that if you move the system and heat the planet beyond a certain level, it unleashes these forces of nature that then cause more carbon dioxide and methane and greenhouse gas emissions to the atmosphere. And then you get into a situation of runaway heating. One of these, and there's many of these feedback loops, but just one to explain very briefly, has to do with the permafrost across the northern latitudes. That is thawing. And as it thaws, it releases massive amounts of carbon dioxide and methane into the atmosphere. Scientists very much fear a sort of collapse where the thaw would get so great that the temperatures would just go outside of our control. In 2019, the UN chief declared at a climate conference, the point of no return is no longer over the horizon. It is in sight and hurtling towards all of us. And the Juliana panel, which I'll return to later, recognized the problem is approaching the point of no return. This is because of those dangerous tipping points. They said that absent some action, the destabilizing climate will bury cities, spawn life-threatening disasters, and jeopardize critical food supplies. This was Oregon just a few months ago in the canyons right outside where I live. And this is what happened from devastating wildfires. So this is now affecting every part of the country and every part of the world. The UN chief also said that the world must do several things to prevent runaway climate change. First, and this was back in 2018, start bending the rising curve of carbon emissions down by 2020. Now, last year, I couldn't see any real feasible way of doing that. I didn't think it was going to happen, but COVID struck. And one of the consequences of COVID was an abrupt shutdown of economies, which did decrease carbon emissions by about 8%. But this decrease has to continue to achieve 45% within 10 years. That is a huge amount of carbon dioxide decrease necessary. And then full decarbonization by 2050. And so what this means is that we have to start right now dialing back this fossil fuel energy system. And that means keeping fossil fuels in the ground and replacing fossil fuels with renewable energy. But we've had decades of fossil fuel development and combustion and exports as a result of our federal subsidies and other actions that promote the system. So the federal government allows leases offshore and onshore. It provides permitting for burning and exporting fossil fuels. And at several different points, it promotes this fossil fuel energy system. The government has known for decades that this would cause chaos right about now. And there are many, many documents that explain this. But one of them, which I think is really telling, is a letter to Nixon, which shows how far back the government knew. Warning of sea level rise. And the letter says, goodbye, New York, goodbye, Washington, for that matter. In the Obama administration, too, the Secretary of Energy, Stephen Chu, was talking about climate and said, I don't think the American public is gripped in his gut what could happen. We're looking at a scenario where there's no more agriculture in California. And he said, I don't see how they can keep their cities going either. The Juliana panel said this country is now expanding oil and gas 4 times that of any other nation. And so we're exporting, we're perpetuating this system in other countries as well by supplying them with fossil fuels. Now, when I try to describe the climate situation to just everyday people, I refer back to this quote oftentimes by John Holdren, who was the science advisor to President Obama. And he said back then, the current situation of the world in relation to the climate problem is that we're in a car with bad brakes, driving towards a cliff in the fog. And so what does that really mean? That means that back then, there was no plan. Now, President Trump came into office 4 years ago, and he came in on a campaign platform where he wanted to promote $50 trillion worth of fossil fuels. And he has organized the fossil fuel policy to promote it as quickly and rapidly as possible. And so now if you can picture this car, we're all in the back seat of this car, and we're strapped back there. And our children are back there, our grandchildren, and all future generations are in the back seat with us. And now we have a driver of the car who is pressing his foot down on the accelerator, going towards that climate cliff as fast as he can. And so in a sense, you can think of today's talk as asking, is there any way of pulling the car over before it goes over that climate cliff with all of us in it? This climate situation, we have to recognize, is what the law calls sui generis, and that means there's no equivalent. There's never been anything like this in the legal system. And what has happened is, because of the timing of it and the tipping points, the President of the United States now has unfathomable power, never really fathomed, I think, by the founders, because it is a climate emergency and we are so close to the cliff. So now I want to go into statutory law and talk about how this came about. How did the executive power become so great? Well, these statutes were passed in the 1970s, again, the Clean Air Act, the Clean Water Act and such, and they gave vast discretion to the agencies. And the agencies were supposed to implement the laws for the public, but they became captured over time. And it's easy to see how this happens. Big industries and profiteers give huge campaign contributions to presidents and governors, and then they appoint agency heads who are basically political operatives, some coming right from the industries that the agencies are supposed to regulate. And those political operatives then press upon all their staff the industry agenda. And pretty soon that agency starts using its regulatory power and authority over public lands and resources as payback for the campaign contributions. And so the laws quickly became tools allowing the very destruction they were designed to prevent. And they not only allowed them, they legalized an entire system of destruction. I've written about this in my book, Nature's Trust. But the bottom line for the climate system is the Clean Air Act, while it had authority all along to regulate the greenhouse gas emissions, has never been used comprehensively to regulate greenhouse gases. And in this statutory system, the court's role has retreated because the courts get very narrow claims under statutory law, and they approach these claims with tremendous deference to the agency. They sit back. And oftentimes, if there is a successful lawsuit that, say, the citizens bring, they will remand that suit to the agency and say, do the process over again. But it just returns the process to the same spin cycle of environmental law that produced the flawed result in the first place. And what we have from 50 years of the statutory law and judicial interpretation is a passive judiciary. And that is dangerous because what has happened is the executive branch has gained unprecedented control over the nation's resources. Congress has not done anything to rein in the president's control. It has been basically missing in action. And you can see why, because congressional legislators get so many donations from a fossil fuel industry. And so while this problem was very clear and becoming ever clearer by the year, decades ago, the government never dealt with it. And we had decades squandered that could have been available for a jobs transition, for an equitable transition away from fossil fuels to renewable energy. And now we are at the edge of the cliff having to do this through what are called deep decarbonization pathways. And the good news is there are pathways to achieve those goals that the scientists have put for us, saying this is what you have to achieve, a 45% reduction within 10 years and then decarbonization by 2050. There are ways to do that and there are pathways, but it will take a lot of work and there's no time to waste. I do want to point out that Professor Dernbach and Michael Gerard from Columbia have done enormous work publishing a compilation of the hundreds or thousand, I think, legal steps necessary to bring about a decarbonized society. So there's much work to be done. I want to now transition into the third part of my talk, which is a fundamental rights approach. We've talked about the climate emergency. We've talked about statutory law and how it actually brought us to this point. Because it legalized the very damage that the laws were designed to prevent. So now we're going to talk about a fundamental rights approach. And that approach is really implicates the separation of powers. When you think about it, we only have 3 branches of government. And the fundamental rights, in a way you will see soon, accesses the judicial branch in a way that statutes have not. So while there are many fundamental rights approaches, I'm going to focus on the public trust principle because I think it underlies, in some respect, all of the other approaches. And we'll talk about judicial enforcement of fundamental rights, and then we'll move on at the end to the climate role of courts. So moving into the public trust, I like to put up this cartoon. I don't know if you can see it very well, but it's a fracking operation. And the drillers say, we've hit something impenetrable, and that's the public trust. The public trust is bedrock. It underlies all of the statutes. In terms of the 3 branches of government, it is enforceable in the courts as a constitutional premise. And so it maintains that tension between the 3 branches of government that is so vital for democracy. If ever one branch gains too much power, we have the real threat of tyranny. And that's what we're facing with the executive branch right now, which has resulted from these decades of a passive judiciary. Well, it has always been the fundamental role of courts to say what the law is, interpret constitutional rights, and also enforce constitutional rights and the fundamental rights of citizens. And throughout history, we've had many, many eras of case law where courts have stepped in after finding violations of fundamental rights, and they have created remedies to bring those institutions back into compliance. So in the civil rights era, the public housing cases, the Pacific Northwest treaty rights litigation, which I've studied quite a bit, and the California prison litigation and others, courts have served a very unique role in enforcing the constitutional rights of the citizens. And these are not win-loss cases. These are not divorce cases. These aren't contract cases. These aren't, tax appeals. Those all have very simple winners and losers. These are cases that are very different. They involve long-standing institutional violations that are just baked into the system itself. Usually they've persisted for several decades. And these are cases where the court itself engages with the institution to bring about corrective practices that will not violate the constitutional rights anymore. So in these cases, the courts have several tools. First, they issue declaratory judgments, by which they declare what the rights are and whether they've been violated and what it will take to bring the institutions back into compliance. They can issue backstop injunctions to prevent the immediate harm, and they can issue what are called structural injunctions. And these are broad injunctions designed to achieve the institutional compliance that often takes a long time to achieve. So in these injunctions, the courts typically order a remedial plan that the defendant, the government, comes up with, and then that plan is supervised by a court in the ongoing jurisdiction of that court. So again, these are not cases that just go away. These are cases where the court maintains jurisdiction for quite a long period of time. Now, when the government, and it's usually a government entity that's being sued, but when the government defendants come up with a plan to remedy the constitutional violation, the courts exercise what I've called, and I just coined this term, comity deference to the other branches of government. And that means that the other branches choose the policy measures and corrective actions. It's not the court's job, and it's not the court's constitutional role to make the policy choices and fashion the actual remedy. That's the job of the other branches of government. But the courts provide a forum to do that will ensure constitutional compliance. And they will review the plan that the defendants come up with to make sure it abides by the constitutional parameters that they've set forth in the declaratory judgment. And what this does is it forces productive attention by the government or the agencies that have, without court intervention, just let this problem persist for decades usually. The courts will impose time-based milestones. A judge will say, government defendants, you bring back a draft plan within 3 months. And then when that comes back, if there's a part that's deficient, the judge might say, I want to see your revision, your suggested alternative within 6 weeks. There is tremendous judicial work that goes into this phase, this remedy phase, because the court itself is reviewing the remedies and vetting them and putting its intellectual rigor into the process itself. And one thing that is striking that I think people might miss because they think of courts as adversarial forums is a judge will often find areas of agreement within the party, between the parties, and will often force the parties to talk about their areas of agreement. And so this can be a way to push through what would otherwise be this enormous inertia caused by political stalemates. The courts also serve a huge public informational role. In the climate context, for decades, and it's still going on, the fossil fuel industry and the government is perpetuating still the idea that climate crisis is a hoax. And in a court, it's important to bear in mind that alternative facts are perjury. They're subject to rigorous cross-examination. There's an oath against lying. And so you have a fact-finding process that will not allow disingenuous narratives. So turning now to the public trust as a fundamental right, as part of, one of many, but we'll just talk about this one. The public trust has been described as the law's DNA because it's really so essential to the vision of a democracy. The public trust, as Professor Dernbach already eloquently noted, sets up this idea that there's an ecological endowment that present and future generations are entitled to. So government is the trustee of these natural resources because government is the institution that endures through time. And the assets in the trust are called the res. So the fish, the wildlife, the air, the waters, those are all part of the res of the trust. That's the wealth, or Professor Dernbach referred to a bank account. So that the wealth in a bank account would be money, but in a natural trust, it's natural resources. Present and future generations are the beneficiaries of these. And so while they don't control the trust, the trust has to be managed in their sole interest. And the trustee has all the power to manage, but has none of the beneficial interest. So courts hold trustees to a firm fiduciary obligation to protect the assets in the trust. It's as simple as that, because the trust has to endure for future generations. And so there's this very firm duty of protection. Charles Wilkinson, Professor Charles Wilkinson, said the public trust is rooted in the precept that some resources are just so central to the well-being of the community that they must be protected by distinctive judge-made principles. In other words, this is the idea that you don't want the executive branch or the Congress to get so much power over these resources that they will deplete them for future generations. And so the trust has been deemed a principle with constitutional force, the slate upon which all constitutions are written. And as Professor Gerald Torres says, it is one of those inherent rights that predates the Constitution. Well, a landmark case that many may know about already, but some may not, announcing the public trust in 1890 was Illinois Central Railroad versus Illinois. And in that case, the United States Supreme Court confronted this situation of the state of Illinois legislature had conveyed the entire shorefront of Lake Michigan in Chicago to a private railroad company. just conveyed it to a private railroad company. And this was shoreline that the citizens needed for fishing and navigation and commerce and to carry out their daily activities. And so the Supreme Court said, you can't do that, legislature. You don't have the power. You literally don't have the power to convey out public resources of this nature because they are held in trust. They are crucial to public well-being. They're held in trust, and therefore you don't have the power to privatize them. And they said conveyance of the shoreline would be a grievance that would never be long borne by free people. And I've always loved this quote because it brings to mind really the crucial nature of the trust in any democracy. Well, in 1971, skipping quite ahead, these citizens of Pennsylvania affirmed by 4-1 margin Section 27 of the Pennsylvania Constitution, which is called the Environmental Rights Amendment. And many of you already know this, of course, but the text of the amendment is here, and it says the people have a right to clean air and pure water and the preservation of these parts of the environment. And it said that the government was a trustee with these duties to conserve the natural resources. And again, Senator Curry, who is, I believe, with us today, drafted the text of that amendment. It took 40 years for the courts to actually give it teeth and enforce it. But in a case in 2013, Robinson Township versus Commonwealth of Pennsylvania, there was a challenge to Act 13, which was a law that the legislature had enacted to promote fracking around the state. And it basically preempted local regulation of fracking. And so you had all these communities that couldn't protect themselves against the environmental and social and cultural effects of fracking because the legislature had taken it away. The Supreme Court of Pennsylvania overturned that on constitutional grounds. And Chief Justice Ronald Castile wrote a 162-page plurality opinion. So it didn't have the majority at the time, but it was later endorsed by the Pennsylvania Supreme Court. And so I really focus on his opinion because it was a pioneering opinion that in my textbook on environmental law and the public trust, Professor Michael Blum and I call it one of the most detailed judicial pronouncements of the public trust in modern times. It was a path-breaking decision. And again, it has been substantially endorsed by a majority of the Pennsylvania Supreme Court. And here is what Justice Castile said and wrote. He said that all citizens have inherent and indefeasible rights, that legislative power is not absolute. And he said people make a social contract forming their governments, and people give power to their governments, not the reverse. This was a refreshing dose of oxygen in an asphyxiated democracy that has come from really a corporate stranglehold on our government. He pointed out that Article 1 of the Constitution of Pennsylvania reserves to the people that they hold back these rights that are of such general and essential quality as to be ensconced as inviolate. And among those rights are the environmental rights articulated in Section 27. And so his point was that Section 27 did not just create these rights, it embodied and articulated rights that had been present and held back by the people in their social contract with government. He said the right is not meaningless, and it is on par with basically other civil rights that we might think of. And this opinion has a huge effect nationwide and in fact, perhaps worldwide, because all states are founded on the same logic. Now, not all states have, a constitutional amendment like Section 27, but all states are founded on the same principle that the people hold back essential rights. The Oregon Constitution, the California Constitution, and all others express this reservation of rights. And so what Justice Castile did was basically put out the premise of the public trust as a premise rooted in something that we all have. He said that the trust doesn't contemplate, this unrestrained discretion of a trustee. And therefore, the court has to enforce the trust. And that is very true. If the court doesn't enforce the trust, it is meaningless. He also elaborated the fiduciary principles. And I really don't have time to go into detail on this. There's much more that could be said, but I want to underscore that he highlighted the duties of loyalty and prudence and impartiality. Loyalty is that duty which, in theory, would prevent a senator from voting on a bill if that bill affected an industry that donated a significant amount to that senator's campaign. Very important duty. And then substantive duties to protect the resources. He said it was an affirmative duty to protect them. And also the duty to treat all beneficiaries equally. As Justice Castile pointed out, Act 13 would have resulted in a very disparate impact of fracking. And so this might be a kernel to support environmental justice approaches. In the remaining time I have, I'm going to talk about how the courts have used the public trust principle to address the climate emergency. Atmospheric trust litigation is a field of litigation that was launched by a nonprofit organization, Our Children's Trust, in 2010. And it treats air just as air is one of these trust assets. Indeed, air was mentioned in the Roman origins of the public trust. The cases that were brought back in 2010 were brought against states, and there was one failed federal case. But I want to focus on the case right now that is pending in the Ninth Circuit Court of Appeals, and Professor Dernbach mentioned it. It's the Juliana versus United States case. It was a case brought in 2015 on behalf of 21 youth plaintiffs from across the United States. It's a case against multiple federal agencies, and it was brought right here in Oregon, in the Federal District Court of Oregon. It's called the biggest case on the planet because it challenged the whole fossil fuel policy of the United States. So this wasn't sort of a little incremental challenge that you find under statutory law. It challenged the system as a whole. The complaint alleges that the government has acted with deliberate indifference to the peril it knowingly created. And it compiles evidence going back decades. The government knew it was creating danger through the fossil fuel emissions and did nothing about it. This case is the first case that has put an environmental problem to the courts, to federal courts, in a fundamental rights frame. Again, other cases have been brought under statutes, but this asserted a fundamental right to a climate system. And it asserted substantive due process and equal protection claims, but also a public trust claim. So I'll focus on the public trust claim. The relief requested was what you see in institutional litigation, a request for declaratory relief, and also a request for this judicial decree that would have a recovery plan to decarbonize the nation and phase out fossil fuel emissions. In 2016, Judge Ann Aiken ruled on this complaint, this case, and right out of the box, she said, this is no ordinary lawsuit. It's a civil rights action. She denied the government's motion to dismiss the case and said it should go forward. She found that the public trust is an inherent attribute of sovereignty applicable to the federal government, that it predates the Constitution and is enforced through the Due Process Clause. And she applied the very same social contract theory to this case that Justice Castile really spearheaded in the Robinson Township case. And she quoted that case and cited that case. And she said the trust encompasses inalienable rights. What are those rights in the climate context? This is it. She said, I have no doubt that the right to a climate system capable of sustaining human life is fundamental to a free and ordered society. And so that, if you will, is the constitutional right to a climate system. The trial was set, and doing the discovery, and everything was ready to go. People expected a bifurcated trial where the court would first deal with a declaratory judgment and liability rulings and then get to the remedy stage. And in this process, the plaintiffs had developed enormous evidence on alternatives to decarbonize the economy. But the Trump administration lawyers, the Department of Justice, made unprecedented efforts to derail the trial and finally succeeded by gaining a premature appeal in the Ninth Circuit Court of Appeals. Now, I might say something about this. The standard progression of a lawsuit is to have trial first, including a hearing on the remedy, and allow the court to really flesh out the facts on the remedy. And then that goes to the appellate court. This completely detoured around that whole process. And so there was no fact finding by the court to hone in on a viable remedy. And the case arrived in the Ninth Circuit Court of Appeals as a hypothetical, and it was set up for something like an advisory opinion because there was absolutely no work done to create or fashion any remedy of the trial. While the case was pending before the Ninth Circuit, there were massive destructive wildfires in California, and the youth plaintiffs filed a petition for emergency injunction to stop 100 projects that the Trump administration had ready to go. And the question was, could these projects just blow through the remaining atmospheric carbon budget and put us over tipping points? So the Ninth Circuit had that before them. The ruling focused on the court's ability to provide a remedy in the case. And the court was very divided when it issued its decision in January of 2020. The majority of 2 judges found that we are on the eve of destruction and government has knowingly caused this crisis and is hastening what could very well be an environmental apocalypse. And yet, even though they found that the constitutional claims were viable or arguably viable, they said, we assume these are viable. They said, we cannot provide any relief. The courts have no role in this at all. That the plaintiffs have to look to the political branches of government for relief, the same branches that have caused this crisis and brought us this emergency. There was a demolishing dissent by Judge Staten, who was sitting by designation as a federal district court judge. And she said the government, insists that it has the absolute and unreviewable power to destroy the nation. And that her colleagues say that there's nothing fit for the judiciary here. But she said that the court's role is to enforce the fundamental rights. And that applies in this climate context as well. She said that government is walking the nation over the cliff, and the courts serve as the ultimate backstop and as the branch of government that is constitutionally required to enforce the fundamental rights of the citizens. She also said, as a trial court judge, that the request for a plan is not anything novel, and she cited back to the eras of institutional litigation that I had mentioned earlier. And I think for Judge Staten, her trial court experience probably made this less of a hypothetical case. She could really envision how the remedy would play out and how there would be a hearing and vetting and areas of agreement. She ended her opinion by saying, history will not judge us kindly. When the seas envelop our coastal cities, fires and droughts haunt our interiors, and storms ravage everything in between, those remaining will ask, why did so many do so little? It's worthy of noting, as I conclude here, that courts in Pakistan, Colombia, the Netherlands have all stepped up to require climate action by their governments. And they've rejected the idea that courts have no role. So right now, as we sit here today, there is a petition for en banc hearing filed that's still sitting in the Ninth Circuit Court of Appeals. After their loss, the youth plaintiffs, attorneys for the youth plaintiffs, filed a petition which asked the full court to review the panel's decision. And this is, a step that litigants can ask for. And it is still pending in the Ninth Circuit. To be granted, there has to be a majority of those Ninth Circuit judges saying, yes, we think this deserves a rehearing by a larger panel. And that larger panel would be comprised of 11 judges. But there's still been no ruling on that petition. And so as I'll sum this up, we've talked about the climate emergency. We've talked about how statutory law really brought this to us. And we've talked about fundamental rights approaches. We're ending with the court's role in the climate emergency just by noting that there are 2 frames. One is just cross out the judicial branch altogether having no conceivable role. And when I think about that frame, I think about Professor Douglas Kaiser's famous now quote, he's a Yale law professor, that judicial nihilism in the face of climate change means denying their power. These courts cower before catastrophe. The other frame is as a co-equal branch of government, providing a forum for problem solving using what I call comedy deference and traditional tools. And I would submit in sum that on the eve of destruction, the law may actually be relevant only in that latter frame. Thank you. And I think we will open it up to questions. But thank you so much.
Well, thank you, Mary. That was quite wonderful. I appreciate your. One of the values of Zoom is getting speakers in from afar, and so we're delighted to have you with us today. There was a question in the chat. Actually, there's several questions now in the chat, and I'll just go through them in the order that they came in. Do you believe that the upcoming change in administration will affect the federal government's position in the case?
Yeah, I knew that question was coming. It's been on my mind too. I don't know. Let me just provide a frame. I'm just not in on the internal discussions of the Department of Justice or the Biden administration or any of that. So I don't know. But I will provide a frame that the Department of Justice is a huge impediment to climate justice. That no matter what administration, it seems that the Department of Justice, the US Department of Justice, and I would say also state attorneys general, many of them, not all, have this view of a privatized government. In other words, they try to quash the public trust, and they try to have no supervision or no accountability. And so they are very largely responsible for this growing ecological tyranny in the executive branch and for the idea that the court should play a hands-off role. The Department of Justice gets a lot of deference because they're great lawyers, but I think the best thing the Biden administration can do, actually two things, is one, instill a public trust obligation in the lawyering for these cases, not just this case, but other cases, so that they don't just sort of defend, as private attorneys would, the actions of the executive. Their clients are really us, the people, but they've come so far astray from their obligations to the people that they are promoting a privatized view. And the second thing the Biden administration could do is look at settlement opportunities, how to actually make productive work out of this case.
Okay, fair enough. I'm just going to take the questions in order. Thank you, Dr. Wood. Do you have any advice for activists with no legal expertise, locally or nationally?
That's a great question. And yes, I do. I think that part of the reason we got into this position was because people thought the statutes were the end all and that they were protecting our environment. And so people just withdrew. They thought the government was working for them. And we know now that's not the case. And so activists just have to be ever vigilant and ever active and organized constantly. And I think that one thing we don't think about is the citizens' role in these cases. Judges cannot be lobbied, so they are politically insulated. But they definitely feel the pulse of the people. And so the more the people express opinions in letters to the editor, in blogs, interviews on the radio, all of these things, demonstrations in the street, and the more they show up in court hearings, the more the judiciary can sense this very clear moral responsibility to protect the climate system. And this is true throughout all the major eras of the United States, all, the civil rights era and so forth. Very much courts were influenced by the pulse of the populace.
Okay. Next question is, can there be some kind of donation auditing that specifically would preclude legislators from voting in conflict of interest situations? And the follow-up, which is related, I think, is have there been lawsuits to hold legislators who vote against public trust when they have received donations that present conflicts of interest?
Oh, that's such a great question. I think this is where it's at. If you want to clean up government, until Citizens United is off the books, it's on the books, it allows all of these donations. And so let's assume you can't get rid of the donations, but you can use the duty of loyalty to challenge individual senators or governors or even state land boards who are trustees. Any of those decision makers who are accepting donations by corporations that stand to gain from their decisions should be held accountable as trustees with a duty of loyalty. The answer is there has not been yet litigation challenging the decision making on a violation of duty of loyalty grounds. So what you would do is you would ask for recusal from of the senator or the port commissioner or the state land board person. And then short of that, litigation if they don't recuse themselves. And the idea is just very simple. And Justice Castile put it right, the duty of loyalty, right in that opinion. By creating a conflict of interest, the decision maker, the trustee, was violating the duty of loyalty to the beneficiaries. So it'd be a really good case to bring, I think.
So the next thing on the chat here is not a question, but just a statement. For those of you who are not inhabiting the chat feature, and it's from Joy Boudreau, who's managing this for us. And it basically, if you want CLE credit, the link is now in the chat function. The next question is, you seem to take a dim view of the executive's role, but wouldn't you agree that President Obama did more to advance climate action with the Clean Power Plan, Paris Accord, transportation rules, and so forth, that we could ever hope for from Congress or the courts today?
Oh, that's a great question. President Obama was not a friendly climate president until the very last time that he spent in office. And up until that time, he promoted oil and gas drilling and oil pipelines. I've written about this in several articles. And so he was deemed an environmentally friendly president, but for climate, it actually wasn't the case. And his Clean Power Plan, if you looked at the reductions that would have accomplished had it actually gone through and been executed, it wasn't nearly enough. And so I think what we have to do at this point is not just view progress as adequate. We have to line up progress with the climate reality that scientists tell us we're up against. And that climate reality is issuing certain deliverables. We have to reduce carbon dioxide emissions in a quantitative manner to match the reality to keep us from going over tipping points. And so really that is the question. It's not, did someone do some good? It's, did a president do enough good to avoid those climate tipping points? And oftentimes that just it's missed in the political question. It's missed because people assume that a president who speaks in a climate-friendly manner acts in a climate-friendly manner. And they may be in small measures. And certainly President Obama did a lot with the transportation sector. I grant you that, but it was not enough.
So one of the interesting things about doing this on Zoom, we have a big moot courtroom where we usually do this program, but one of the interesting things about doing this from Zoom is hearing from people who I know I'm quite clear are from way out of town. Here's a question from Keith Hirakawa, and I think is it Albany, I think, and he says, have you seen any pushback on the trust idea and how far this idea can go?
Hi, Keith. Yeah, there's pushback on any fundamental rights idea. So I think the biggest pushback legally is from the government itself and the attorneys. I think we often miss the role of the attorneys in litigation, the attorneys on the government's side. And the pushback is just this parade of principles that basically creates the notion of a privatized government. For example, I'll give you an example. Magistrate Judge Coffin, in the proceedings leading to the oral argument before Judge Aiken, Magistrate Coffin, who first had the oral argument in the Giuliani case, asked the lawyers for the government and for the oil and gas industry or fossil fuel industry, said very clearly, do you think government has the power, if it wants, to sell the whole Pacific shoreline and 12 miles out to Exxon Corporation? And both of them said yes. And so the attorneys for the United States, this was for the Obama administration, the Department of Justice attorneys said, yeah, oh yeah, Congress can sell the whole Pacific Ocean if it wants, and then Exxon, to Exxon, and then it can turn around and charge citizens for using it. And Judge Coffin just felt, and so did Judge Aiken, and so do many, that violates the whole essence of the public trust. The public trust means no, government has limited powers. It cannot sell off resources that are crucial to the public. It can manage them, but it can't sell those off. So Professor Hirakawa, I think that's a great question. And yes, the pushback is there, but the less obvious quarters is from the government attorneys themselves.
So here's another question that is seriously out of town. This is from Eileen Porras, who's at the University of Miami. And she says, is there a way to square the public trust doctrine with a rights of nature approach, or is there a risk that they work at cross purposes?
Yeah, that's a great question too. And I've thought about that quite a bit. And I wrote about that in Nature's Trust in chapter 12 as well. So there's an approach called rights of nature, and there's an approach called earth jurisprudence. There's many variations of this, but the idea, can you make them compatible? Of course, I think you can. So I talked about that in Nature's Trust and said, really, all of nature is a beneficiary of this public trust principle, or should be, and along with humans. And the earth jurisprudence approach, which is a very deep and reflective approach, to my understanding, often tries to look for different tools to achieve similar ends of ecological balance. And rights of nature would be one of those tools, public trust another. But yes, I think the way to merge them would be to say that government has a duty to nature and humans all as a beneficiary class of nature's trust.
Okay, so here's a little bit of a longer question, and I'll just read it. While our ability to vote and attempt to put more individuals in government who do support climate change legislation is powerful, the recent election showed us that there are more and more individuals who believe, among other things, that climate change is not real. What other methods of informing the public do you feel are effective ways to attempt and change the minds of the public so we can increase public pressure of government and the judiciary by increasing believers?
Well, I love that question. And let me say, I'm not in an ivory tower. I get out and I'm in the West. So I go around, I go to Western communities. I have yet to see people who really seriously deny climate change. I think that's overblown. Now, I know that there's polls that say there are some people that still deny climate change. I think maybe they deny it until their house is burned down. And I think climate disasters are striking with such frequency and horrifying magnitude that most Americans believe in climate, are worried about climate disasters. So I don't think that should be our focus. But if you want my opinion on how to bring it to people, what I do in Western communities, Idaho, Oregon, Utah, wherever I am, Washington, I talk about it. And I think that's one thing we all should do. We talk about COVID all the time. We should talk about climate anytime we are interacting with strangers. We talk about the weather. So when we talk about the weather, talk about climate. That's the best thing we can do. That makes it sort of a reality that all of us share. It doesn't discriminate according to political lines. And I think that's the best thing we can do, is just really talk about this as a very shared reality and a shared threat, not politicize it, but talk about it in ordinary terms to people, just regular people.
Okay, great. So there are two more questions in the chat function, and I think with the end of those two questions, we'll wrap it up. The first of these, are there any things that can be done if the Ninth Circuit chooses not to take up the full court request which having 10 judges appointed by the Trump administration makes it unlikely.
Yeah, I don't know if it's unlikely, but so I don't know if it's unlikely, but in fact, I don't know anything about what they're doing in the Ninth Circuit, but I do know one thing. It's sat there for a long time, which means it's controversial. That's the one thing you can ascertain from the length of time between the time the petition was filed and now. It's definitely got to be attracting attention. What else can be done? I suppose another lawsuit could be filed. If the Ninth Circuit rejected it, the plaintiffs, and I'm not involved in the litigation as an attorney, so I don't know what their strategy would be, but they could appeal it to the Supreme Court of the United States, or they could not appeal it to the Supreme Court of the United States. They could bring another case. I know one thing, it's very important to keep the litigation in play. Maybe not specifically a case in play, but the litigation in play, because you've got to keep these fundamental rights out there. Remember, Senator Franklin Curry's drafting came to fruition 40 years after he put the cap on his pen. 40 years. And so to keep the judicial system engaged, keep the public engaged, is, I think, a very important thing, and to not give up. And I have no sense that these plaintiffs would give up. They can't. Their lives are at stake. Their futures are at stake. And young people know this. It is horrifying to really talk to a young person about their climate reality. They know that.
So the last question, I think a lot of us would agree, begins with, thank you for such an insightful presentation. And then it goes on to ask this. There's been discussions on the concept of ecocide, mass destruction of the environment, to be enforced by the International Criminal Court. Would you consider this to be a useful mechanism to hold governments accountable in terms of not encouraging policies which endanger the environment?
That's a great question. I'm not sure how to answer that question because I have not reflected precisely enough. It's a weighty question, but let me give you the answer I can give. We have come to a point where it is not a mystery what is happening, and we are at the edge of the cliff. And when you have a president backed up by attorneys in the Department of Justice and agencies and industry leaders that are pushing down that pedal, and we're strapped in the back of that car about to go over the cliff, I think that we have to discuss the moral and human rights and even crimes against humanity implications of those individuals in those positions. We can say, oh, sure, everybody relies on fossil fuels. Yes, but it is the industry executives, the agency heads, and the Department of Justice lawyers who have this crystallized scenario in front of them. And yeah, I think that the discussion has to open up to their moral culpability, whether it's ecocide or genocide or whatever. 100 years from now, if we are able to look back, if some people are able to look back, they will be shocked at the decisions made, just as Judge Staten said, when the seas envelop our coastal cities and destroy these lands. People will wonder, why did so few take such little action? So that is the question on the table for everybody every day from this point on.
Well, that I think is a perfectly appropriate way to end a powerful presentation. Mary, thank you so much. I wish I could solicit applause from people, but if nothing else, we can do a thumbs up. So thank you very much for joining us. It's been a privilege, and we wish you all well. Thank you.
Thank you, and it's been my true honor. Thank you, everybody.
Widener University Commonwealth Law School is the Pennsylvania capital's only law school, with 3 specialized centers of legal scholarship through its Law and Government Institute, Environmental Law and Sustainability Center, and Business Advising Program. Widener Law Commonwealth offers an exceptional learning experience that is personal, practical, and professional. Visit commonwealthlaw.widener.edu for more information.